Good day to everybody on social media channels. I hope you are all doing well today. Today, I wanted to speak to you about um, court disputes and what my views are on the process, which is called litigation. Now, I think one thing I'd want to make clear is that what a lot of law firms don't tell you is that sometimes litigation can be a waste of time and money because you don't achieve anything by it, and you just expend money and you expend your good time, and you incur the stress of going through the process. If your dispute is sort of low level, and when I say low level, let's say it's under £10,000, and then it's going to be sort of small claims, and then your cost recovery may be somewhat limited in those circumstances. But let's say, my view is, claims from sort of, low level to 20 or 30,000 pounds are very likely to result in costs that could be similar in amount to what you're claiming. So I would certainly recommend thinking twice or three times before embarking as a claimant and thinking what my alternatives might be. Because the risks you run is, one, no matter how strong your lawyer tells you how strong your case is, every case will have weaknesses and strengths. And there, in my view, there is no such thing as an unlosable case. Because of the way litigation works, it is all open. It is a presentation of legal case by each side. And the judge's role is to make a preference. He may make a preference on credibility as well as law and as well as fact. So it is in some senses non-exact science. It can fall down to the individual personalities of the judge, and I've had plenty of experience in the past where judges have exercised their discretion or their views in a totally different and unexpected way. So I would certainly think about, do I need to go down this route and spend my own hard-earned money on this? And even if you win, what sort of cost recovery are you likely to make? Because anything sort of over £10,000 may be, you may get some recovery, but it may be 60 or 70% of your costs. You don't get everything unless there are sort of exceptions there. And you may even have to have another trial about costs that you're claiming, which will, of course, cost more money. So, in essence, what my view is a lot of law firms may take you on this merry-go-round, and you may not achieve much at all. And therefore, I would probably say that you may be better off trying to resolve the dispute yourself informally, or you could sort of quasi-mediate the dispute yourself or get a mediator in. Now, that's certainly going to be cheaper, depending on, the experience of the mediator. But I would certainly recommend giving it a try. Now, I have drafted some free sort of dispute resolution directions for anyone who wants to use them. So please just get in touch with me and I can let you have a copy. I may actually just embed it in some document or link somewhere. But in essence, you will be just trying to resolve the matter yourself, because the question is that you must, with any sort of commercial dispute, you have to take your own emotion out of the picture. And you need to understand, well, what is the other side's position? Because you will often learn something which is quite unexpected by engaging with the other side, rather than continually just looking at things from your perspective, or maybe emotional perspective. And this is a common problem in a lot of sort of disputes. And although it's easy for me to say take the emotion out of it, the question is, you mustn't cloud your thinking with emotions. It has to be a commercial decision for your business. So yes, I hope you found my video and my views useful. And yeah, if there is anything, please get in touch. Have a good day. Bye bye.